We begin tonight's broadcast with a major ruling from the U.S. Supreme Court. In a 6-2 decision Tuesday, the justices upheld a Michigan constitutional amendment that bans affirmative action in admissions to the state's public universities. 7 other states have similar bans. This decision may encourage even more states also to adopt affirmative action prohibitions. Joining us to discuss this important decision is one of the lead attorneys who has been fighting for years to have the ban lifted. George B. Washington joins us from Detroit. Also with us is Hughey Newsome. He is joining us from Dallas, Texas. Hughey is with Project 21, an agency that filed an amicus brief supporting the ban on affirmative action. Welcome to both of you, gentlemen. Thank you for being here on Arise America.
Thank you for having me.
I think I want to start with you, Hughey, while George is getting into place. Tell me, what is your reaction to the Supreme Court decision that effectively effectively bans affirmative action?
No, I think the justices of the Supreme Court, at least the 6 that found in favor of the ban, acted correctly. I mean, what you have here is a proposition that was created by the legislative body, duly elected by the citizens to carry forth the needs of the citizens. There is no constitutional violation here with this ban. So I don't see why anyone would find this ruling short. This ruling is the correct ruling. The will of the people was carried out with the proposition putting forth the ban, and the Supreme Court justices respected that. It's good to see that the legislative will of the people is being respected by the Supreme Court.
However, I think there are those who would disagree with you, Hughey, in that this country was really founded upon and certainly exhibited throughout its history a system of institutional bias against minority groups, including African Americans, including Native Americans, including Latinos, including females. And so that is how this law was put into place in the first place. So my question to you is, do you think we have gotten past all those institutional biases in this country?
Of course we haven't gotten past those institutional biases, but here you have a situation. Let's look at the history. You have the situation where the University of Michigan was sued because it was trying to deal with the dearth of minorities that were able to get into the University of Michigan without affirmative action. So if you remember, Jennifer Gratz brought forth that lawsuit against the University of Michigan, and of course the court back in 2003 gave more or less a split ruling, going against quotas but going in favor of some weighting towards minorities back in 2003. But at the end of the day, you have an admissions policy that basically gave favoritism to minorities. So to say that this affirmative action ban is helping us to dodge this institutional racism is wrong, because you've got an admissions department that is saying that it is going to give favorability, not equality, but favorability to minorities. Well, so I don't know how we're addressing institutional bias if the Supreme Court had ruled differently.
I'm just a little bit curious, Hughey, how you see it as favorability when in fact it was put into place to grant access to groups who didn't have access. That's not favor, that's equality, is it not?
No, I don't necessarily agree with that. If you were to look at a race-neutral admissions policy, that in itself is saying that I'm not going to look favorably towards one race or the other. If you want to look at the lack of access that minorities have to get into these institutions, you have to address why it is that when you look at race-neutral admissions policies, minorities aren't able to get into these institutions at the same rates, equal to the proportion of the population, to their proportion of the population. That is the root of the problem. But to say that it's because of an institutional bias in the admissions policy is erroneous, in my opinion, because these institutions are being sued because they are trying to make incoming classes more diverse.
We now have George B. Washington, who has argued this case and fought on this issue for quite some time. George, I'm wondering if you heard the last response that we just got from Hughey, and if you did, can you respond to it? Is it erroneous?
Oh, I think this decision is an historically tragic decision. It's a decision which says that the states of the United States, and really that means the white electorate, can tell black students and white and Latino students that they don't have the same right to fight for the same kind of special programs that veterans, that poor students, that rural students, that alumni, and everybody else has. This is the exact opposite of equality. And what it does is say that the University of Michigan is forced by law to ratify the inequality in secondary and elementary education, which absolutely nothing is being done about. What it means is that our universities, which train our leaders, are going to be resegregated at the exact moment we are becoming a majority-minority country. This is a decision comparable to Plessy versus Ferguson. It will mean de facto segregation in Michigan, in California, and across the country.
And that was, in fact, my next question. Hold on just a minute, Hugh, and I'll let you respond in just a second. But, George, what is the practical? You've worked in this area for so many years. You have a wealth of experience to speak to this. What is, then, the real-world effect of this decision?
Well, what it means is that there's been a drop of 1/3 to 1/2 in the number of Black and Latino students at the most selective schools at the University of California and the University of Michigan. It means, whereas 10 years ago there were 40 Black lawyers graduating every year from the University of Michigan, there are now 10. It means that there are many fewer Black and Latino doctors, so that the citizens of this state will not have the kind of care that they are entitled to. The ramifications are terrible. It means an attempt at resegregating the society at exactly the moment we are becoming a majority-minority country.
Go ahead, Hughey.
Well, here's the problem. Here's the problem with your argument. You're saying that minorities either have to have a crutch to get into these institutions, or something is lacking so that they can't get in on their own merit. You're looking at the symptom and not the root of the problem. Why aren't you looking at addressing why it is that minorities can't get in at these rates without these admissions policies? Why is it that I can't have a race, if I have a race neutral admissions policy and African Americans, you say half at the rate of acceptance, why is it that you're not addressing what's causing that problem? You can't say it's institutional racism in the admissions groups, because these admissions groups are being sued because they're given favorability. So where is the racism?
Well,
George?
the racism is very simple. Racism is very simple. If you look at those tests, rich kids do much better than poor kids. City kids urban area kids do much better than rural kids. And white kids do much better than Black and Latino kids. And that's not because that they're any smarter or anything like that. It's because of the bias in those tests and the bias in the educational system. And nothing is being done to change that.
If you go to the jobs that those law schools are feeding and those undergraduate programs are feeding into, you still have the same problem, right? So at some point you have to have some assimilation and some exposure to all those systems that you're talking about that are considered racist. So why aren't we addressing the issue? Go ahead.
Well, I want to jump in here, if I may, George.
Sure.
And Hugh, I want to ask you this question, because your proposition for your last point is that why is it that you assume that Black people cannot get into a university on their own merit? But doesn't that require an assumption that merit is rewarded? And don't we have documented history in this country that merit is not often rewarded? In fact, sometimes it's denied based on that individual.
We have documented history, but we don't have documented history in these cases. If you look at the University of Michigan, George brings up
we absolutely do.
Okay, George, I'll let you respond. Let's let Hughey finish his point.
You've got an admissions department. You've got an admissions department that was being sued because they were giving favorability to minorities. So how can you say that there's a bias there? I don't understand that argument. So how is it that you have an admissions department that is saying we are going to seek out and more or less cut corners to make sure that we have a diverse class? So why can you can't have it both ways. You can't say that the admissions departments that are being sued because they're looking at favorability are at the same time biased. It doesn't make sense to me.
George, I'll give you the last word.
Nobody is cutting corners. What we're saying is that if you're considering what qualifications a Black or Latino student has, those students bring a type of knowledge, a type of skill, and a type that is simply not known in the high-test white suburbs, which are so privileged. And the fact is, once the admissions, what Proposal 2 does is prohibit the admissions departments or black and minority citizens from advocating these programs. So what you get is the resegregation at the University of Michigan and the University of California. Those are facts. You can't deny it. And what you're saying is, really, we should have 1/4 as many lawyers, black lawyers, as we did 10 years ago. That's what's happening.
And unfortunately, gentlemen,
and nothing is being done on that.
Unfortunately, Jim, we're going to have to stop this very robust and very important discussion right here. George B. Washington, Hughey Newsome, thank you to both of you.
Thank you.
Thank you.